Hi, good afternoon, everybody. Thank you so much for joining my webinar today. My name is Romy Jurado. I'm an attorney here in South Florida. I started a firm. It's called Jurado Associates. We're a law firm in Florida, and we practice in different areas of law. Those areas of law include real estate law, probate, state planning, immigration, litigation, copyright, and trademark protection. Today's class, I'm going to be focused on probate, but of course it has a lot to do with real estate, and I look forward to answer all your questions. I am recording this class, and I hope to share with everybody once the recording is done, and also my presentation, which I will share with you right now. I look forward to sending it to you all once the class is over, hopefully tomorrow. If there's any questions at all, please feel free to place them on the Q&A, or you can put them on the chat, and I'll be more than happy to answer all your questions. Thank you again. So there we are, probate for realtors. I'm going to focus this class in probate, but there's, of course, a little bit of estate planning, and there is real estate as well. So please feel free to ask me any and all of your questions. Let me get started. So what is probate? Probate is a court-supervised process for establishing the validity of a will, identifying and gathering the assets of a deceased person, which we'll refer to as a decedent, also paying the decedent's debts, right? And winding up the decedent's financial affairs so that then we have all the assets to be distributed to whoever are the heirs of the beneficiaries. If there is no will, then the court will determine who gets what. And that will be done according to Florida law. And the type of system that we use is called per stirpes. And I'll explain that in a minute. So when is probate necessary, right? And how is this important to real estate agents, of course? Well, probate may be necessary to transfer ownership of the decedent's probate assets to the decedent's beneficiaries. This comes into real estate a lot because you may find property, for example, a plot of land that your client had and the husband died and now the wife wants it, but it was titled differently, or maybe it was bought when the husband was single. So we may need to have probate to transfer that property. Even if it's homestead property, we may need to have probate. So it just depends how the property was titled and whenever the person died, what happened to it. Also, if the decedent left a valid will, the court will need to admit the will according to the procedures to probate that transfer ownership of any probate assets to the named beneficiaries. Sometimes people think that having a will is sufficient and that with that you don't need to do any probate because you already have a will. That's not correct. Having a will is not enough. If you have a will, that you will still need to open up a probate in order for the assets of that will for them to transfer to whoever are the heirs or the beneficiaries. If the decedent had no will, right? So probate then is necessary to pass ownership of the decedent's probate assets to those receiving them under Florida law. And again, that system is called per stirpes. Some assets do not require the probate proceeding to transfer ownership. Probate may be necessary also if there is any type of financial affair, right? Or if the person that passed away was subject to a personal injury lawsuit and there is some money that is going to be received from that injury lawsuit because the person died, such as wrongful death, then you may need to open up a probate in order to receive that money, for the heirs to receive that money. So what do we mean when we talk about probate for real estate? Where you're going to see this a lot, whether there is an heir, a seller, or a buyer, the definition of probate in real estate never really changes. Someone owned real estate, whoever that person was, that person died. And then in order for the rightful heirs to have title to the real estate, to sell, convey, transfer, the heirs have to go through this formal court proceeding called probate to officially transfer title. So situations where I have seen this myself is you have a listing agreement. And the person that signed the listing agreement, who's the one that owns the property, passed away. So now what do you need to do? Well, that property cannot be sold and nobody can sign to accept the contract unless it's the executor of the probate state. And in order to have that, you're going to have to open up a probate. You're going to have to open up a probate to see who the executor will be or who the personal representative is, for the personal representative to sign any contract, any offer accepting the sale of the property. And then once that offer is accepted, you're going to need the probate court to approve the sale of that property. So it makes the situation a little longer, but it's not impossible. We have been able to obtain approvals from the court process in as little as 3 days to sell a property. However, if you don't have the probate set up as soon as the person dies, you don't know who the heirs are, or there is a potential dispute, that is when things can take really long, and you may have an offer and not be able to accept it. So my recommendation is, if you have a listing agreement and somebody passed away, find out as soon as possible if there is a will, find out as soon as possible who's going to be in charge of the probate, get them to work with a probate attorney. We're delighted to help, so that we can start the process as soon as that happens. And then as soon as you received an offer, we're able to send it to approval and we can approve it right away. But in order for us to get there, we need to have opened up a probate, appoint a personal representative, for all the heirs to be in line. So, there's different things that need to take place. So I see it when you're listing a property. I also see it when you already have a contract, and there we have a little bit of less time. So let's say that you had a buyer, and that buyer was going to buy a property. They made an offer was accepted, and now the seller died. Again, we need to, as soon as that happens, you need to push the seller's agent, to push the seller's attorney, or whoever the heirs are, to start the probate as soon as possible. Otherwise, you will not be able to sell that property. You will not be able to do a closing because the personal representative has to sign the transfer documents. I have also seen it where the person died. There is, they list the property for sale, but then the agent doesn't realize that the actual owner is dead. So is the son, the daughter that's listing it. One, they have no legal ability to list the property for sale. So that contract is technically invalid. So if you find out that somebody died, then don't list the property. Talk to a probate attorney to see who has the right to list the property or to get the probate open. And we actually had a dispute with that because it was a situation where the dad died and the daughter is the one that listed the property when the dad had already died. The brother didn't want to sell. So now the agent had a signed offer by the daughter, but the daughter had no legal ability to sign on behalf of the probate state because no probate has been opened. She wasn't appointed personal representative. So now it's a whole mess because the buyers were selling, we already signed, we want to buy this property. The daughter is saying, no, I don't, I want to sell, but my brother doesn't want to. So what needed to happen in that case is the probate needed to happen. The property needed to go to the daughter and the son. And now they were going to fight it off in a partition action because one didn't want to sell and the other one did. So to avoid all of that, whenever there is anybody, you see a property that's owned by somebody that has passed away, or you find out, get them to speak to a probate attorney so that they can list it appropriately. So you can sign the contract with the person that is actually legally able to sign the contract. And then you don't have any of these disputes at the end. So why should realtors care about probate? Well, you want to avoid wasting time. You don't want to have list of property with somebody that signed that had no legal ability to sign. Now you listed it, you market it, and you can't sell it. Also, because you're dealing with the wrong person. And because unless you're dealing with the person that was appointed personal representative by the court, right? Then they're the only ones that have the ability to sell a property. So now what I do is I try to at least get all the heirs in line to agree so you're not wasting your time. Also make sure that the contract is subject to court approval because there's some rigid deadlines in the contract that depending on who the probate attorney is, which court is being accepted at, if the heirs are fighting or not, court approval may take longer than it usually does. So whenever you have a situation where the person died and you're going to accept an offer, make sure that it clearly states in the contract that it's subject to court approval. Another thing that I have seen. So let's say that you have a property and the people inherited, whoever, the son, the daughter, the cousin, whoever they inherited, they know nothing about the property. They may not even know the square footage of the property or the condition of the property. So make sure that your contracts make no representation regarding the condition of the contract and that the buyer does a survey. The buyer needs to do a survey, even if they're buying cash, even if the bank doesn't require it, I don't care. Because you don't want them to rely on what you said as an agent or on what your seller is saying, because your seller really doesn't know anything about the property, right? They're just inheriting it. So you don't want the buyer to have a legal claim against them. So what you want to do is encourage, if not force the buyer to get a survey so that they know what they're really buying, to do their inspections, make sure that they understand that there is no absolutely no representation being made regarding the state of the property completely as is. They need to do their whole due diligence because your client may not know anything and you also may not know anything. So just make sure that that happens to protect yourself from liability and protect your seller from liability. Probate states, right? So we have two. We have with a will, which is called testate, and without a will, which is called intestate. Testate succession, right? So when the decedent has a valid will, because now we also have seen issues where people come in, they want to sell the property, they want us to do the probate, and they show us a will that is not valid under Florida law. The person, so do you understand? Whenever there is property in Florida, there's going to have to be a probate open in the state of Florida to sell that property. Unless that property is not subject to probate, and I'm going to talk about that, you're always going to have to do a probate. Even if the person never set foot in the United States, the only people that have jurisdiction over that property is a Florida judge. So I have a lot of situations where foreigners buy property here, they never set foot here, or they come very little, they pass away in their country, and then they list the property, they're ready to sell, and they realize that they cannot sell the property unless it's, in probate. And the situation is that the will that they have may be valid under their jurisdiction, let's say in Peru, Portugal, Brazil, but when it comes to being admitted in Florida, it's not, because we have specific rules of what we require for wills. So my suggestion is whenever you're advising foreigners, one, you don't want them to be subject to probate. Why? Because there is a 40% state tax that they're going to have to pay. Two, their will may not be valid in Florida. So if there's any way to avoid property to be subject to probate for foreigners, I highly recommend it. And there are ways we can help them structure that. But anyway, when the decedent has a valid will, right, the role of the probate court is to distribute property according to the decedent's instruction in the will. They have to also appoint a personal representative as indicated in the will, unless it is a summary administration. So first thing we need to do is find out, is there a will? And then actually Florida law requires that the custodian of the will deposit it with the clerk within 10 days of receiving information that the testator has died. A will can also nominate minor children, and a will can be used to disinherit specific individuals. In other countries, I find out you are not allowed to disinherit individuals, right? They have something called forced heirs. In Florida, you can disinherit whoever you want. There's only one small protection, and that is for homestead property. You cannot disinherit your wife, and you cannot disinherit your minor children. But besides that, you can leave your assets to whoever you want. There's no such thing as forced heirs in the state of Florida. So intestate succession. This is when there is no will or there is no valid will, which I was telling you, foreigners sometimes have an invalid will. So then the spouse may come in and say, this is, oh no, the spouse gets it. The brother may come in and say, my brother did a will, he left everything for me, and here it is. And then they give it to us, and that will is invalid, right? Under Florida laws, it's invalid. So now when we bring that into probate, there's no will. So now the wife is going to get all of it, not the brother. So it's so important, if you plan to disinherit somebody, if you plan to, if you're an heir to somebody that has property in Florida, that the will be valid under Florida law. Otherwise, the laws of the state of Florida, which are called per stirpes, are the ones that are going to regulate who gets what, right? And usually, if the person that died was married, their spouse is going to get the property. If they had children, the children together with the spouse. And there are different orders, and it's called per stirpes, which we will analyze depending on, who is that died, if they have homestead property or not. And here's a little chart that kind of gives you an idea. So there's two types of probate that we deal with. There's something called summary administration and another one called formal administration. Summary administration is like quick administration, right? So this is a simple form of administration that does not require the appointment of a personal representative, can be completed when the decedent has been dead for more than 2 years, and the will does not direct formal administration. So this is a quick one. We have a will, the decedent died more than 2 years ago, then we can do summary administration. It's also cheaper. Can also be completed when the value of the entire state subject to administration in Florida, less the value of any exempt property from claims of creditors, does not exceed $75,000. So if, for example, the person that died had a homestead property, that is exempt from the probate subject from the probate asset subject to creditors' claims. So we are still able to do summary administration, even if the property was $600,000, as long as the other probate assets don't exceed $75,000. So if in the bank they had $30,000 and the homestead property is worth $600,000, we can still do summary administration. It's a quick procedure. I highly recommend it if at all possible. So it's either the value of the estate subject to probate, it's $75,000 or less, or the person has been died for more than 2 years. If that's the case, then we can do summary administration and we can be on our way really quick. All right, formal administration. As the name implies, it's more formal, takes longer. It is usually needed when the assets of the decedent are in excess of $75,000, or the decedent has been dead for less than 2 years, right? Or if for some reason you want to get a personal representative appointed by the judge. So let's say that you seek to sell real estate during the probate process. For instance, you may have many beneficiaries, heirs, and you would rather have only one individual sign the closing documents. Then we're going to need to appoint a personal representative. And for that, we need to do formal administration. Also, I have seen this where, for example, there is a 401k here, a 401k there. They don't want to give you any information unless you appoint a personal representative. Then we need to do a formal administration. Formal administration is also recommended when you have multiple creditors. You need to provide formal notice, or the borrower is deceased and the bank does not want to provide information without a personal representative. We see that a lot. There is a bank account that the decedent left, but the bank wants to give no information unless a formal administration is done or a personal representative is appointed. So what is a valid will, right? So for a will to be valid, it must be in writing, so important. Signed by the decedent, so this is the person that died, and witnesses, and comply with the execution requirements set by Florida law. In a will, the decedent can name the beneficiaries whom the decedent wants to receive the decedent's probate assets. The decedent can also designate a personal representative, Florida's term for an executor, to administer the probate estate. All these things can be done with a will. And what is a valid will? Well, Florida Statute 732.501 tells us that any person who is of sound mind and either 18 years of age or more, or an emancipated minor, can make a will. We have been contacted many times by people that tell us that their mom wants to do a will, but she is basically not mentally there anymore. We can't do a will, right? There's a provision of the law that says that if they have a lucid interval, then you could do a will, but it's really hard to tell. So usually we recommend people to do wills when they're, good, when they can think all the time, when they're there. So you won't have any issue to say whether your will was done and you had sound mind or not. Also, a will must be signed by the testator. This is the person doing the will at the end of the document, not on top, not on the side, not in the middle. For it to be valid, it has to be signed at the end of the document. If the testator is unable to sign the document, some other person may subscribe the testator's name at the end of the document in the testator's presence, okay? So if for some reason the testator cannot sign the will, that's okay. It can be done at the testator's direction. Also, it must be witnessed by at least 2 attesting witnesses who also must sign the will in the presence of the testator and in the presence of each other. The witnesses shouldn't be people receiving money under the will, because then they could be used to fight it. So for a will to be valid, very important, it has to be done by somebody of sound mind, over 18 years of age, or an emancipated minor. It must be signed at the end by the testator. If the testator cannot sign, it can be signed by somebody at their direction, subscribe. Also, it must be witnessed, okay, by at least 2 attesting witnesses who also must sign the will in the presence of the testator and in the presence of each other. And I don't recommend that those witnesses are interested parties in the will. It's better if they're not. Let's talk about homestead property. If the owner of a property has a home in Florida that is his or her primary residence, Florida homestead law must be considered. Okay, there's Article 10, Section 4 of the Constitution of the State of Florida and Florida Statute 732.4015, parentheses 1, provide that the decedent of homestead may not be devised Okay, so the decedent homestead may not be devised if the decedent has a spouse or a minor child. As I was telling you, you cannot disinherit your spouse or your minor child if you have homestead property. Now, there's some exceptions there, but be careful. It may be devised to a spouse if there's no minor child. So if there's no minor children, you can give it to your spouse. A surviving spouse can waive homestead rights in writing with a valid prenuptial agreement. The prenuptial agreement must be clear and explicit. I'm very careful with that because you can still use it to fight it. Per Florida law, statute 732.401, if not devised as authorized by Florida law in the Constitution, then what happens? The surviving spouse shall take a life state of the homestead with a vested remainder on the decedents and the decedent per stirpe. So what does that mean? If the property was owned by the husband, right, and the husband died, then the surviving spouse will get to occupy that property throughout her lifetime, and the children will get it when she dies. That's it, if there's minor children. Also, the surviving spouse can elect to take half of the homestead as a tenant in common with the remaining undivided 1/2 interest in the homestead vesting in the decedent's descendants per stirpes. So that's another option. The spouse can take half of the property and then the decedent's descendants per stirpes the other half. So that's another option that we can do. We also have a term that's called a preterminative spouse. When a person makes a will and marries after the making of the will, the surviving spouse generally gets what she would have gotten if the decedent died intestate. Unless there is a prenuptial or postnuptial agreement addressing the issue, the will provides for the spouse. The will clearly discloses that it does not intend to make a provision for the spouse, but also the surviving spouse can elect something called the elective share. So that gets a little complicated when the person that died did a will, then they marry after. There's an analysis that comes into place to see if the spouse gets anything, and they usually do. So don't get tricked or tell your clients. Sometimes they're told by the other family members, no, he didn't leave anything for you. There was a will, everything was sent to my mom, not to you. That's not the case. You want to have that checked because they may have a right to obtain something. So what if a person dies without a will or legal heirs? That can happen too. But pursuant to 732.107, property reverts back to the state of Florida as a last resort. I have done a couple of wills for people who basically have no heirs. They have no family, they're alone, and they want for the property to go to charities benefiting cats, benefiting kids, benefiting dogs, and that all can be done as long as they have a will. Otherwise, Florida law kicks in and it reverts back to the state as a last resort. Then the property is sold and the process paid to the chief financial officer of the state. These cheated funds are retained as part of the state school funds, and after 10 years, the state's rights to the proceeds become absolute. So my recommendation, if you have no heirs and you want to give it to a specific charity, do your will while alive, let the charity know, so that way, whenever you pass away, that happens and it actually takes place. A lot of people will trick you when you're older, I have seen it, make you sign documents to benefit them. And if that's not your intent, just make sure that the charity that you're going to leave your funds to knows, so that way they track it. All right, so I mentioned personal representative before, and I want to explain to you a little bit of what the person does, and also for you to know that they have a right to receive compensation from the state, usually around 3%. So there is this person appointed by the court to oversee the administration of the probate of the decedent state, who must comply with the following. They must notify all heirs and other interested parties that the will is being submitted to probate. They must identify and take control of any state assets. They must file tax return and pay taxes. They must pay any creditor's claim. They must manage any assets such as investment or real estate while the will is being administered. And they have to sell all the assets to satisfy any claims of the state, filing all the necessary documents and other paperwork with the court, distributing the assets to the heirs, and preparing and submitting a final accounting to the court. All of this is what a personal representative does. And because of that, they have the right to be compensated from the probate state, usually 3%. I have been asked to serve as personal representative. I will do so under certain circumstances. If you are ever asked to serve as personal representative, you can do so too. You can be named in the will. But of course, understand that it is, there is work involved, but for that, you're able to be compensated. If there is nobody named in the will, right, then there is an order of appointing personal representative. So in testate states, this is a will, the personal representative will be appointed, whoever is there, or a successor personal representative. If there is none, then the person selected by the majority of the beneficiaries can be the personal representative, or one of the beneficiaries. If there are many, the court selects the more qualified. So the court, so first is whoever you name in your will. Then is the person selected by the majority of beneficiaries. And lastly, if there are too many, the court can appoint the person that would be most qualified to serve as personal representative. In intestate states, so these are people that die without a will, the surviving spouse will be appointed as personal representative. If not, the person selected by the majority in interest of the heirs. And lastly, the heir nearest in degree, if there are many, the court selects the more qualified one. Under Florida Statute 733.302, any person who is sui juris and is a resident of the state of Florida at the time of death of the person whose state is to be administered is qualified to act as a personal representative in Florida, unless under Florida Statute 733.303, a person who has not been or is not convicted of a felony, right? Convicted of abuse, neglect, or exploitation of an elderly person or a disabled adult in any jurisdiction, mentally or physically unable to perform the duties of a personal representative, or is under the age of 18 years old. If you have any of this, then you are not able to serve as a personal representative. So it's very, hopefully you haven't been convicted of a felony. Hopefully you haven't been convicted of abuse, neglect, or exploitation of an elderly person or disabled adult in any jurisdiction. You need to be mentally or physically, able to perform the duties, and you are not under the age of 18 years old, then you can serve as personal representative. We have a lot of foreigners. So under the statute 733.304, a non-resident of the state of Florida may qualify as a personal representative if the person is legally adopted child or adopted parent of the person that passed away, related by lineal consanguinity to the decedent, a spouse or brother, sister, uncle, aunt, nephew, or niece of the decedent, or someone related by lineal consanguinity to any such person, the spouse of a person otherwise qualified under this section. So in those instances, we could have the personal representative be a foreigner, not be a Florida resident. So I've mentioned all these things about probate, and you might be wondering, well, who wants to go through that? What can I do to avoid it? It seems very complicated. Could be true. So let's talk about that. What can we do to avoid it? So if you have real estate title under tenancy by the entirety, then you avoid probate. What do I mean? When husband and wife purchase real estate as a married couple, and one of the spouses survive the other one, then the other spouse can simply record the death certificate, and we have tenants. We have the other spouse, surviving spouse, be the owner of the whole property, but they need to record the death certificate. This is all great and dandy if they bought the property while they were married. If you bought a house now and you get married 2 years from now and you passed away right after, this will not protect you. So what do you need to do then? You need to do a transfer of title from yourself to yourself and your spouse as tenancy by the entireties. So that way, when either one of the spouses died, the other one gets it by simply recording the death certificate. If you have ownership of property, could be your homestead, could be condominiums, could be commercial property, any type of real estate, as tenancy by the entireties, then all you need to do is record the death certificate of the spouse that died, and the other one should get it. You also have something called joint tenants with rights of survivorship. So let's say I buy a property with my friend, and it is our agreement that if one of us dies, the other one gets it automatically. Well, then we need to own it as joint tenants with rights of survivorship. That means if I die, she gets it. If she dies, I get it. All I need to do is record the death certificate. Not to be confused with tenants in common. Tenants in common means we each own 50-50 of it. And if one of us dies, our heirs get it, right? If you want to avoid probate, not have to go through probate, then you would do joint tenants with rights of survivorship so that whoever survives gets title to the property. Another one is live state deed or ladybird deed. So with this one, upon the death of the life tenant, the remainderment becomes the owner. So for example, the mom owns it, right? It's a life tenant, so she cannot be kicked out. She has the life tenancy. And as soon as she passes away, the remainderman, the son, becomes the owner by recording the death certificate. That's a life estate deed. That can be done with any people. They don't have to be related. I have seen where Peter owns a wildlife, and as soon as Peter died, it goes to Maria or it goes to Jose. It doesn't matter. For life estate deeds, ladybird deeds, you're not required to have any type of familiar relationship. For joint tenants with rights of survivorships, same thing. There's no requirement to any type of familiar relationship. Tenancy by the entirety is the one that only works when it's husband and wife. Somebody's asking me, can a life estate be canceled or can someone be added to it? So let's talk about the life estate again, right? So the regular life estate will be, I get to occupy it while I'm alive, and then as soon as I die, it goes to whoever I put there as a remainderman. Now I can give myself a couple of rights and say, I can sell it if I want, I can mortgage it if I want, I can do whatever with it. If the deed says that, then yes, you can do that, even though you're a life tenant, because you have all those rights reserved, right? And if you don't do it, it goes automatically to the person that's left. But if you do that, if you sell it, if then that's it. There's no more life tenancy because you sold it. So it depends on what your deed says, right? If when you make the life estate deed, you reserve rights, such as the ones that I mentioned, then yes, you can do all of that. But if you didn't, then now you can't. All right, let's see. Can we get a PDF version of this seminar? Yes, you can. I will send everybody a follow-up email tomorrow with the recording and the PDFs. What areas do you service? Okay, well, we do real estate law, probate law, estate planning to avoid probate, trademarks, copyrights, business law. We represent people buying and selling businesses all over the state of Florida. We serve as, doing the documentation, the closing, all of that. Trademarks, copyrights, and litigation. All those things we do right from our office in Miami. We serve all the state of Florida. And if it's for trademarks and immigration, it's all over the United States. Okay, trust. Trust is another way to avoid probate. You can create a revocable trust, which means you can make any changes during your lifetime, or you can make an irrevocable trust, which means once you make it, that's it. You cannot change it. You will have to name a trustee. If you make a revocable trust, then you can be your trustee. And then once you die, you name somebody else. So the trustee basically manages the assets of the trust for the benefit of the beneficiaries, whoever you listed on the trust. It's not enough to just form the trust, right? You need to fund the trust. So if you created a trust and you want to transfer property, make sure that you do the deed to trust and actually transfer the property. We have seen issues where the trust is created, the family thinks, oh no, we're going to avoid probate, and then boom, the trust is not funded. So be careful with that. Somebody's asking me if I'm bilingual. Yes, I speak Spanish. I'm Peruvian. Everybody speaks Spanish in my office, so we're fully bilingual. Thank you. Designated beneficiaries is another way to avoid probate. So if you get anything from today's class, get this. If you have a bank account solely in your name, go to the bank and say, if something happens to me, I want this payable upon death on this person. That way, if something does happen to you, the person doesn't need to go to probate for $5,000, $10,000. All they need to do is go to the bank and say, I'm the designated beneficiary, give me the money. And then that way it's not subject to creditors either. So if you get anything from this class, is to go to your bank, and if you have an account solely on your name, tell them who do you want for that account to be payable to upon your death. So that way, whoever that is, they don't have to go through probate to get $5,000, $10,000, $20,000. And of course, get proof of that being the case, and then give it to whoever that person you think it's going to be receiving your money. Because otherwise, sadly, the banks may not do it right. The person may think that they're the payable upon death designated beneficiary, and they're not. Other ways to avoid probate, as I was telling you, is of course to add a beneficiary of the bank account. Life insurance avoids probate if you have designations there who's going to receive it. If you didn't put anybody, or all those people are dead, then it goes to probate. Annuity contracts, retirement accounts, right? Your 401k, all those things, they avoid probate as long as you put in your beneficiaries. If you do this and you appoint beneficiaries there, then you don't have to go through probate, right? You can just simply, that's it. Your heirs will just go to the bank, go to the 401k, go to the retirement account, go to the life insurance and claim the benefits. But you have to let them know. A lot of times we have people come into us and they're like, listen, my dad died and I know that he had a retirement account. Nobody's giving me information. I know he had life insurance and nobody's giving information. I don't know where to look. Now they're sad dealing with the passing of the family member, but they also have to deal with the uncertainty of not knowing where stuff is at. And sadly, there's no registration. There's nowhere for me to go and see that this person have a life insurance. We have to call all the insurance companies. And then the life insurance people, you know, they get smart and they're like, oh, we won't talk to you unless there is a personal representative of the state. So now you have to open up a probate to have somebody be appointed personal representative in order to speak on behalf of the state. So advice, if you are using any of these things to avoid probate, let the other person know so that they can take charge and do whatever they need to do when that time comes. We do a lot of estate planning. We do estate planning to plan to avoid probate. We do estate planning to designate beneficiaries. We do all of that. We also do probate all over the state of Florida. We deal a lot with probate for foreigners, people that don't reside here. And of course, probate dealing with real estate. We understand how difficult closings are. You want to get it done as soon as possible. So we try to resolve it as soon as possible. So if there's anything I can do for you, please reach out to me. Let me see if there's any more questions. My email's there. My phone is there. That's my website. I'm very responsive through Instagram too, and all of our handles is there. And my personal handle is in the bottom. Let me see if I have any more questions. 1 second. I don't see any more questions. Well, I hope you have enjoyed this quick and dirty presentation. I like to, to give you guys all the points in the shorter amount of time possible, because I know you're all busy. Again, my name is Romy Jurado. I'm an attorney here in the state of Florida. The name of my law firm is called Jurado & Associates, and we serve in the different areas of law, such as real estate, probate, immigration, litigation, estate planning, of course, trademarks, copyrights, and we're here to serve the real estate community. So if there's any questions that you have regarding this presentation or any other topic that I cover, please feel free to reach out to me. I really want to thank you for joining today. Thank you for your time, and I wish you all a fabulous weekend. Take care. Bye-bye.